2024, we have a very special guest, Chief Justice of India, Justice D.Y. Chandrachud. Sir, hearty welcome to PTI and also wishing you and your family a very happy new year, sir.
Thank you very much, Etasham, and it's a pleasure to be with you this morning. Happy New Year to you, to everyone in PTI, and to your families.
Thank you so much, sir. As we ring into the new year, how do you see, when you look back, how do you see 2023 in terms of the performance of courts all over India and failures and successes of the courts all over India and the performance of judiciary as a whole, because there has been a lot of changes in the last 1 year. How do you see that?
Etasham, we were coming out of the shadow of COVID. After COVID descended, it was a very difficult time for the Indian judiciary. We were able to cope because of the sound technological infrastructure which our judiciary has, and our performance in that sense, even during the COVID times, was unprecedented. But at the same time, COVID did bring in very serious challenges in terms of staff, in terms of the lawyers, for the judges themselves, because families were involved. It led to so many different issues which we had to face within the judiciary. But the last year was a remarkable year, I feel, for the Indian judiciary, because we have taken several new steps to making justice more inclusive, to promoting access to justice. Now, typically, when you look at a court, the public, the citizens view the courts from the perspective of the output, the judgments. But equally, they look at the process which is going on in the courts, because that process has to be friendly enough for citizens, it has to promote access, and it should not be a barrier to any citizen across the nation. We have taken some very unique initiatives in the last year. They're all designed to ensure enhanced accessibility and transparency to the Indian judiciary. Coming to the Supreme Court, for example, we have started live streaming of important cases emanating from the constitution benches. And I believe that live streaming is one signal achievement of our Indian judiciary over the course of the last year, which is intended to take the work of the judiciary to the homes and the hearts of people. The Supreme Court has been regarded as a people's court. And I think there can be no better initiative for us to continue to be a people's court than to ensure that we live stream our proceedings so that people understand the nature of the work which is carried on in the courts. They understand the seriousness with which every individual case, whether it's an important constitutional case or a small case involving somebody's pension, is taken up by the court. So live streaming has been a very important initiative. The second important initiative which I would like to mention is the eSCR portal. There are about 36,000 judgments of the Supreme Court since independence, since the court was established. Now, all these judgments are recorded in English, which is the official language of the Supreme Court. But not all our citizens understand English, and legal English at that. So one of the very important initiatives which we adopted was first to digitize all these judgments, place them in the public realm, and ensure that citizens have free access to these judgments through the electronic Supreme Court reports. But we haven't stopped at that. We have been using artificial intelligence for the purpose of translating the judgments of the Supreme Court, machine-assisted translation, as a consequence of which, as of date, as we speak, about 23,500 judgments of the Supreme Court have already been translated into Hindi. And they are part of the eSCR portal, so that just as you have a free text search portal in the English version of the eSCR, any citizen can access judgments in terms of the date of the decision, the name of the judge, the subject of the decision, so on and so forth, on the basis of a variety of search parameters. And our effort is to translate all our judgments into every one of the recognized languages, recognized in the sense constitutionally recognized languages, and we are moving on that in a very rapid way. Apart from this, The court has been taking very important initiatives for ensuring physical accessibility of our premises. I had constituted a committee chaired by one of my colleagues, Justice Ravindra Bhatt, to conduct an accessibility audit of the Supreme Court of India. And the accessibility audit has revealed very important steps which we have to take to ensure that people, regardless of physical disability, are not denied access in the true sense of the term to the Supreme Court. We've been trying to integrate technology into the work of our courtrooms. The first three courts in the Supreme Court have been equipped completely with 120-inch screens so that people from across the country can watch proceedings, can address proceedings. Lawyers from across the country, parties in person, can address us from across the country. They can submit documents digitally. In fact, my court, as the Chief Justice of India, is completely paperless. The judges don't use paper, and I encourage lawyers not to use paper. All our files are delivered to us digitally, and we are completely off paper. We are now expanding that to court number 4 and court number 5 in another fortnight. The same facilities would be available in court numbers 4 and 5. If you wanted to come to the Supreme Court and you needed a pass, you had to come and wait in a line to get a physical pass. That has been now replaced by the Suswagatam portal, as we call it, as a result of which even the passes for entry into the Supreme Court have been made digital. So a lot of new initiatives on the technology front, which are being adopted not just by the Supreme Court, but by the High Courts. There is virtually a veritable competition now among the High Courts.
Delhi High Court especially.
Yes, Delhi High Court, a lot of High Courts now, Karnataka, Kerala, Tamil Nadu, Madhya Pradesh, Punjab and Haryana. You just name the High Courts and they are doing something new. And I have invitations almost by the week to release a new initiative of the High Courts for the citizenry at large. One of the problems which we found was about the communication of bail orders of the Supreme Court down to the jails. Because it is not enough that we are extremely alert about the need to grant bail in appropriate cases. But these orders must reach the under-trials or convicts, many of them who are under-resourced. They don't have adequate literacy. They do not have necessarily access to legal aid. The Supreme Court has developed a module called FASTER, and now we are implementing FASTER 2.0, which uses blockchain technology, so that through the use of blockchain technology, the orders are authenticated. That ensures that the orders cannot be fabricated and then put out onto the public realm. And we are ensuring that we have control over all subsequent steps which are taken to implement the orders. So the district judge in one of the districts in India who has to pass the bail order consequent upon the Supreme Court granting bail and impose requisite conditions, does that on time. We can ensure that the jailer in one of the jails across India has actually delivered the order. They will report back onto the portal, and all this is capable of being monitored. One of the initiatives which we adopted in the last year to promote gender sensitivity was to come out on a gender handbook. The idea of the gender handbook, Etisham, is that we, in our legal discourse, we must be more attuned to the need to maintain gender sensitivity, so that certain phrases that were routinely used, words which were used in legal discourse, are no longer acceptable. Why are they no longer acceptable? So through this gender handbook, which we are using as a training module across India for training judges, lawyers, paralegal staff, is something which we are working on and which we have already put out into the public realm. We have come out with guidelines for the framing of written submissions. Litigation is becoming very complex. It's becoming complex partly as a result of the economic complexities of our times. Many of the new laws that Parliament has enacted are regulatory laws, like the Insolvency and Bankruptcy Code. This gives rise to a lot of complexity of litigation, and that also reflects in the volume of the paper books which we have to deal with. Today, a paper book of say 20,000 pages is not unique. It's normal. That's the new normal that judges have to deal with. 30,000 pages. When we dealt with the Ayodhya case, for instance, 30,000 plus was the size of the paper book, the documents. When we dealt with Article 370 recently, we crossed that as well. Now, how do we equip judges to ensure that they don't lose sight of important parts of the paper book? So we have put into place a standard operating procedure for the filing of written submissions, for filing of joint compilations by lawyers, all this to ensure that the whole process of presentation of cases is streamlined, that there should not be an element of ambush in the course of legal arguments. Everything should be transparent. So my idea about incorporating technology as part of the judicial process is to make this truly a citizen-centric judiciary, a judiciary which is responsive to the needs of our citizens. So the object of incorporating technology is not to set apart the court from the citizens. It is to enhance transparency, bring out greater participation of citizens in the work of the courts, and to ensure ultimately that we are responsive to the needs of our citizens.
As far as the pendency of cases is concerned, it has always been a big cause of concern. So in 2023, we saw that Supreme Court disposed of a record number of cases. How was that possible? What extra efforts were made for that?
Well, to give you the figures, we disposed of 52,191 cases from 1st of January to 15th of December 2023. And this exceeded our registered filing, which was 49,191, which showcases in a certain way effective case management. We did that at different levels. First and foremost, we did that in terms of streamlined case processing. In the time which is taken between the point when a case is actually lodged in the registry to the point of time at which the case comes up for actual hearing before the court for the first time, that period has been reduced from 7 days or even more, it was sometimes much more than even 7 days, to 5 days or less. We have prioritized certain types of cases, for instance, cases involving bail, cases involving demolition, cases which are extremely urgent, so that those cases can be processed even within a day and can be listed before the court. We have also put into place a procedure by which there is swift handling of certain types of cases, bail, habeas corpus, eviction, anticipatory bail. These cases can be processed and are processed, generally speaking, even in one day. So we have really first and foremost focused on the time which is taken from filing to the listing of a case for hearing before the court. The second important step which we took was for having specialized benches for adjudication of cases. The age in which we live today, and this is not something which is unique to the law, it's across the board. It's an age of specialization. And I thought that it's important that we must have judges with domain expertise hearing certain types of cases which require domain knowledge and domain expertise. So we have, for instance, just to give you one example, 392 Insolvency and Bankruptcy Act cases were resolved in a single judgment. I've constituted 3-judge bench special benches with almost 166 sittings addressing crucial matters and references. The areas where we have had specialized benches are land acquisition. Now, land acquisition cases deal with citizens' rights. Somebody whose land is acquired is looking for the grant of compensation, and it's not a sole individual. A single notification would cover hundreds, if not thousands, of our citizens. So, listing land acquisition cases in the Supreme Court not only ensures that these cases are disposed of by the Supreme Court, but they have a fallout in the high courts, because then those decisions give guidance to the high courts on what the court is deciding in relation to a particular notification or in relation to a particular issue. Apart from land acquisition cases, cases involving compensation. These are basically cases involving motor accidents where citizens across India are affected by motor accidents. Sometimes where a death takes place, their legal heirs are waiting for the grant of compensation by the insurance companies. So we had a specialized bench for compensation cases. We've had a specialized bench for direct tax cases. We have had specialized benches for indirect tax cases, particularly in the context of the GST. We also have specialized benches for insolvency and bankruptcy, the commercial cases that we have today. So setting up domain expert benches where judges who have specialized knowledge in that branch would work on those cases has been really one of the key factors in speeding up disposals. So, but apart from this, we have been focusing on, say, criminal cases. Criminal cases, as you know, are the largest single source of filings in the Supreme Court. So criminal cases are dealt with almost by all judges. But within criminal cases, we have judges dealing with cases in which they have expertise. For instance, there were death references which were pending before the Supreme Court. And death references have to be disposed of at the earliest because somebody in jail under the shadow of the award of the death penalty, you can imagine the psychological impact on that person. There's a societal interest involved as well. So I requested one of my very senior colleagues, Justice Bhushan Gavai, to take up the death references. Death references go to a combination of 3 judges, and that has resulted in the disposal of a large number of cases involving the award of the death penalty as well. So these are some of the steps which we have taken. Greater use of technology in the process, and this is going to be a mission which I'm sure will continue for the future.
Hopefully. So, access for justice, you have been speaking about it since long, ever since you came to Supreme Court. So, how do you think this can be made possible that every individual, every citizen of the country feels closer to judiciary and reposes faith on the system? How do you think, what are the challenges? How can it be made possible?
Well, let me begin by saying that the number of cases which are filed every year in our courts, whether it's the district courts, the high courts, or the Supreme Courts, is a clear index of the faith that common citizens have in the work of the judiciary. Because the kind of work which our courts do is virtually unprecedented in any other part of the world. For instance, the Supreme Court's doors are open to every common citizen. Very few Supreme Courts across the world do the kind of caseload which we handle. And I dare say the same thing is true about the high courts as well as of the district judiciary. The district judiciary is a very important source of concern for me as Chief Justice of India, in the sense that the first point of engagement of a citizen is with the district judiciary. The citizen doesn't go usually to the Supreme Court as a matter of first resort, but to the district judiciary, whether it's for a stay in a civil matter, anticipatory bail, or a variety of other issues which face common citizens. So it's important for us to focus on the district judiciary in terms of its infrastructure, in terms of filling up vacancies, in terms of training judges, and in putting to place better case management systems for handling the work of the district judiciary. And work is going on a war footing on each of these issues. We are looking very closely at the infrastructure of the district judiciary. There's a case which is pending before the Supreme Court, namely the Malik Mazhar Sultan case, where successive Chief Justices have been monitoring the work in the states in terms of upgrading the infrastructure of the Indian judiciary, the district judiciary, filling up vacancies, because we cannot have vacant posts in the judiciary if we have to truly be responsive to the needs of the citizens. So that's on the infrastructural front. For instance, recently, as a result of an order which we passed, Delhi district judiciary will be having close to 250 new courtrooms, which were the need of the hour for that court to attend to citizens' grievances. There are new judges who are joining the system, and there would have been no courtrooms for those judges to sit in. So that's something which we are monitoring. I engage very closely with the Chief Justices of the High Courts to ensure that the infrastructure of the district judiciary and the High Courts is upgraded. Apart from that, it's important to have judges with the right kind of ethos. Judicial training is very important because judges must have the sensitivity to deal with the nature of the cases which they deal with, whether it's cases involving gender violence, whether it's in cases involving human liberty, whether it's commercial cases. If a judge is dealing with an arbitration case, they must understand the importance of arbitration in a viable commercial system in the country. So our judicial academies across India are embarking on very ambitious training programs for judges, ranging from the new recruits through the district judges to the High Court judges themselves. We have the National Judicial Academy at Bhopal, which carries out training for judges across India. And then we have the Supreme Court itself. The Supreme Court, as I said, has launched into innovative schemes for promoting access to justice. To answer your question with just 2 or 3 examples, I think legal literacy and public engagement are very important. The National Legal Services Authority, which is chaired by the senior most judge of the Supreme Court, has been doing very commendable work in promoting legal literacy. They have launched, for instance, the Public Defender Program, which is to ensure that no person who requires legal aid in criminal cases is denied legal aid, and that everyone should have the benefit of a legal aid lawyer who is duly funded by the government, whether in the center or the states. Second, as I've already said, technology is a gateway to justice. And the third important area is judicial infrastructure in promoting accessibility.
And for that, I think the center has increased the budget of judiciary in this financial year. Still, what are the challenges ahead that you can foresee?
Well, as part of the e-courts mission mode project, I'm in fact chairing the e-committee of the Supreme Court of India, which looks after the ICT needs of almost 18,000 courts across India. Phase 3 of the e-courts project is about to be launched, and we have a budget which has been sanctioned by the Union government of 7,000 crores. And we hope that with this budget and the new phase 3 of the e-courts project, we will be entering a new phase in the ICT engagement of the Indian judiciary. My object really is to we must saturate the least technologically equipped districts in the country to ensure that citizens in these districts, particularly in the northeast and in the hilly areas of the country, have every facility that is available in terms of access to the internet. So we are setting up e-Seva Kendras. To tell you something about the e-Seva Kendras, we must admit that there is an internet or digital divide in India. Not every citizen has access to the internet or has access to the same extent as citizens maybe in some of the larger metropolitan areas would have. The object of setting up e-Seva Kendras is that we should make available within the precincts of every court establishment all the services which are provided to citizens as part of the e-courts project, so that no citizen is denied access to the normal services of our courts. And the idea, therefore, is for us to reach out to citizens through the setting up of e-Seva Kendras. We are also now, we have also collaborated with the common service centers, the initiative of the Government of India as part of the Digital India initiative, so as to ensure that the CSCs, which would work at the level of every village in India, would also provide the e-services which the judicial system provides, whether it's in terms of e-filing of cases, in access to information about their cases, about e-payments. E-payment gateways have to be incorporated and are being incorporated as part of the system. Another very important aspect which I would like to very briefly dwell on is the Interoperable Criminal Justice System, which is ICJS. And ICJS basically seeks to integrate every one of the stakeholders in the criminal justice administration: the police stations, the forensic science laboratories, hospitals, the court system, and the jails across India. And therefore, the underlying assumption of ICJS is that if we can integrate diverse stakeholders in the criminal justice administration, we'll be able to produce a more efficient system of dispensing criminal justice. There are, of course, implementation challenges, which we have to overcome. One of the challenges which we face is overcoming resistance to change from traditional paper-based systems to digital processes. Second, ensuring coordinated efforts and collaboration among diverse stakeholders, including the police, jails, the forensic science laboratories. It's not just about putting technology in place, it's also about changing human mindsets, training people. And training has been a very important initiative of the e-courts mission mode project. You'd be surprised to know about how many differently able citizens, citizens who have physical handicaps, are employed by the court system. We have been training them by making them aware of all the tools which are available to them. For instance, to a visually handicapped person who is a clerk in our system, who's working in the filing counters of our system, to use these modern tools and techniques so as to make them productive and dignified employees in terms of not lacking anything which somebody who does not suffer from visual challenges has access to. So we also need to overcome technological barriers, and adapting to new technologies does pose a learning curve for judges, for lawyers, for court staff, and we are encouraging judges to use more of technology. We are encouraging lawyers to use technology. The younger lawyers are extremely well versed in the use of technology. Some of the more senior lawyers, some of the senior judges, because they didn't grow up with technology. So it's work in progress. We are constantly encouraging them to adopt to greater use of technology. One challenge which I must underscore is about the need to maintain data security and privacy, because the Indian court system deals with data pertaining to the lives of individual citizens. So whether they come to court in search of a solution to their matrimonial problems, whether it's in relation to a commercial dispute, whether it's in relation to an act of gender violence, all this implicates data security as well. And this is really a challenge, and it's not something which is faced only by the Indian judiciary. The need to maintain data security on the one hand, and to ensure the privacy of citizens on the other, is a key challenge which is being faced across the world globally. And India is also engaging in finding solutions to balancing the need to have greater incorporation of technology with, at the same time, ensuring that we preserve our data in terms of both security and privacy.
So in 2023, it has been a very eventful year for Supreme Court. If I ask you personally, your personal choice, I mean, so many important judgments were delivered this year by Supreme Court. If you can name one or two which you think these judgments may be authored by you or somebody else, whom you think that these judgments can have an impact on the society?
Well, it's a difficult question to answer. Every judgment, even if it is in a seemingly individual case, has an impact on society. Because while judges decide individual cases, the law which they lay down impacts upon society. So when we decide cases, the outcome of those cases redefines our vision of a just society for the future. Now, having said that, I may have some of my own favorites. I may be criticized for being partisan to them, but technology is very close to my heart. So one of my favorite cases is something related to technology, which was Sarvesh Mathur versus the Registrar General. where we have issued a slew of directions to the high courts to ensure that there is a greater incorporation of technology in the working of the high courts. For instance, we issued one direction to the effect that access to video conferencing facilities shall not be denied to any citizen or to any lawyer. So, for instance, no high court will say that only people above the age of 65 can access video conferencing, because the object of technology is to make it broad-based and inclusive. We also directed that links to the video conferencing facilities should be provided in the cause lists by various high courts. A slew of directions have been issued in Sarvesh Mathur. I've also been dealing recently about a case, the All India Judges Association case, which deals with upgrading the conditions of service of our district judiciary, which to my mind is very critical, because it is only when we provide dignified conditions of work to our civil judges, the civil judge at the lowest level, the junior civil judges, the senior civil judges, the additional district and sessions judges, and then of course the district judges and thereafter above, that we can provide a truly responsive judiciary, attract the right kind of talent. There are some very interesting commercial cases which are not favorites, as I would say, but cases which I would like to, at least one of those cases I'd like to mention, which is the recent judgment of the 7-judge bench on whether arbitration agreements which are not stamped can be looked at when a reference is made under Section 11 for the appointment of an arbitrator. Now, that judgment has not just dealt with the narrow issue of stamping, but it has dealt with the whole arbitration universe. Or, for instance, when we laid down in a constitution bench the group of companies doctrine, that was the Cox and Kings judgment. The group of companies doctrine had to be looked at in a very nuanced perspective, pitchforking India not just as a domestic jurisdiction, but as a nation which is now increasingly looking overseas, beyond borders, as Indian business goes out and foreign business entities come in to India for the purpose of carrying on business and for promoting investment. So some of these cases in that sense, which may not exactly be the cases which the media reports, are cases which are going to reshape the future of the nation in so many which ways. And therefore, I thought I should mention some of them as well.
So now, let me ask you a very crucial question about the collegium system. People might have been asking you this time and again, but this time when Justice Kaul retired, this issue has again been raised. Do you think that this is the best system of appointment of judges that we have? Or what is your personal opinion? How can it be made more transparent, and can we have a better alternative? What is your opinion?
Well, as Chief Justice of India, I'm bound by the Constitution and I'm bound by the law which has been laid down by my own court interpreting the Constitution. And we have the collegium system for the appointment of judges, which has been now a part of our jurisprudence since 1993. And therefore, that is the system which we implement. But having said that, it is equally our duty as present members of the collegium system to make it more transparent, to make it more objective. And we have taken steps, decisive steps in that regard, which I'd like to share with you. One of the steps which we took was to ensure that all resolutions of the collegium are put on the internet, which are put on the website of the Supreme Court, so that people know the decisions that we take. And that promotes a great deal of transparency. That's one thing. Second, we have again put into the public realm the parameters which the collegium applies in the selection of judges to the Supreme Court. And so many of these parameters apply to the selection of the high courts themselves. So those parameters, what are those parameters? First, for selection to the Supreme Court, we look at, when we draw judges to the Supreme Court from the judiciary, that is from the pool of high court judges, we look at their seniority. Because that defines the pool of available judges who can be considered for appointment to the Supreme Court. We look at their merit. We look at integrity. That's the third important aspect. As I said, second is merit. The third is integrity. Fourth, promoting a greater sense of diversity in the Indian judiciary. in terms of the recruitment of judges from diverse backgrounds, be it in terms of gender, religion, caste, marginalized backgrounds. So these are the steps which we have taken to give greater publicity to the norms which we apply. And the last but not the least, certainly, to ensure that the Supreme Court of India does give a broad sense of representation to different regions and high courts across the country. And we have put these as the basic or grounding principles on which we look at judges who are selected for appointment to the Supreme Court. I must also share with you that we have the Center for Research and Planning in the Supreme Court. And I've said this before. The Center for Research and Planning assists in compiling data about judges who are in the zone of consideration. So the leading cases which are decided by the judges, these are circulated to every member of the collegium. We do that, of course, electronically. And the Center for Research and Planning prepares a comprehensive document which is circulated to judges in the collegium. That document helps us better in evaluating the judges whose names come up for consideration and discussion among colleagues in the Supreme Court. But apart from that, every single day of our lives as judges, we are looking at the quality of the output of judges of the high courts. Because on Mondays and Fridays, when we deal with cases going up to 80 cases per bench per day, we are dealing with cases which are decided by the high courts. And those decisions give us a clear understanding of the nature of the cases which are being decided by the high courts, the complexity of the cases which are addressed by individual judges. Therefore, to say that, the collegium system is lacking in transparency would not be correct. We have taken steps to ensure that greater transparency is maintained. A sense of objectivity in the decision-making process is maintained. But I must also share something, and that's my caveat. When we consider judges for appointment to the Supreme Court, we are dealing with the careers of sitting judges of the High Court, people who are in saddle as judges of the High Court. Obviously, therefore, the deliberations which take place within the collegium can't be put out in the public realm for a variety of reasons. Many of our discussions bear on the privacy of those judges who are under consideration for appointment to the Supreme Court. Those deliberations, if they have to take place in a free and a candid atmosphere, can't be the subject matter of a video recording or a documentation. That is not the system which the Indian Constitution has adopted. The American Constitution requires confirmation of judges of the Supreme Court by the Senate. That's not the system which our Constitution adopted. And for valid reasons. The framers of the Constitution were keenly conversant with our conditions, with a multi-religious, a diverse society. And it's important that we also learn to trust our decision-making process. It's very easy to criticize the process, but now that I've been a part of the process for several years as a senior judge of the Bombay High Court, as the Chief Justice of the High Court of Judicature, Allahabad, as a puisne judge of the Supreme Court and now Chief Justice of India, I can share with you that every effort is made by our judges to ensure due consultation at the high courts when selections are made for or before recommendations are made. As you know, at the level of the High Court, judges are drawn from the district judiciary as well as from the bar. The evaluation of the judgments of the district judiciary has followed very well-established parameters. There's a judgments assessment committee in every high court, which looks at the judgments of the judges who are under the zone of consideration. They're assessed, evaluated, and graded. And the output of the judgments assessment committee is placed before the collegium of the High Court when they make recommendations for appointment of district judges to the High Court. The collegiums in the High Court also look at the personnel file maintained with reference to every district judge. They look at complaints, if any, against a particular judge. They look at the entire service record, their annual confidential reports. So the process is extremely well structured, and there is a 360-degree assessment of every district judge before they are recommended for appointment. Insofar as appointments from the bar are concerned, Members of the collegium rely not merely on their own knowledge of those members of the bar who practice before them, but they consult widely amongst other colleagues on the bench, because other colleagues on the bench may have specialization in a particular branch of law, which is the specialization of that particular lawyer. For instance, in the Bombay High Court, if a lawyer is from the Admiralty Bar, you would typically consult with judges who are dealing with admiralty cases. If the lawyers are specialized in commercial law, you would consult with judges who are dealing with commercial cases. So therefore, there's a broad-based consultation. There's a great amount of consultation between the judiciary and the government itself, because after these recommendations are made by the High Court Collegium, the recommendations travel through the state government, the governor, the chief minister, thereafter to the union government. A detailed assessment is carried out by the Intelligence Bureau on the antecedents, character and integrity of each candidate. The reports of the IB are vetted by the Department of Justice in the union government. The comments of the Department of Justice are then sent to the Collegium of the Supreme Court, which reassesses the file, and the assessment is done very carefully by the three-judge collegium in the Supreme Court for the appointment of judges of the High Courts. So the process of appointment of judges in India to the High Courts is extremely well structured. It takes place at multiple levels, involving not just the High Court judges themselves, but the political arm of the government and the other agencies of the government before it comes to the Supreme Court for its final opinion. And we then make our recommendations to the Union of India for the file to be transmitted onwards to the President of India.
So you mentioned about the diversity in appointment of judges in terms of caste, class, and religious minorities, etc. So have you been able to maintain that diversity in your tenure as a Chief Justice of India?
Yes, but let me not just focus on my tenure as a Chief Justice and tell you a little bit about what is happening across India. Let me begin with your question. The pool of judges available for appointment to the Supreme Court consists of people who have been appointed at least a decade earlier to the High Courts. Judges who were appointed to the High Courts a decade ago, say sometime between, I'm one of the oldest in the system, I was appointed in 2000, but judges who were appointed to the High Court, say, between 2005 and 2010, would have typically joined the bar between 1985 and 1990, or little or soon thereafter. So when we look at the pool which is available for appointment to the Supreme Court, that is defined in a large manner by the pool of lawyers in the 1990s. That's why it's important when we talk about the importance of, when we talk about the need to promote greater diversity in the Indian judiciary, we need to look at the pool right down to the grassroots level today. And one remarkable thing which is taking place, which is something which I must share to you as the head of the Indian judiciary, is that when we are making recruitments to the district judiciary across India, in a number of states, in a large number of states, the number of women is exceeding 50%.
In Maharashtra?
In a number of states, Rajasthan, in a number of states, the number of women who are being recruited into the Indian judiciary has crossed 60%. It's gone to 70%. That means that when you have competitive examinations and women have a level playing field, they are doing exceptionally well. Now, these women who are being recruited into the district judiciary today, 10 years or 15 years down the line, they would be the persons who would be, they would be manning positions in the High Court. And sooner or later, they would be coming into the Supreme Court eventually for appointment. The bar has to be made a far more conducive place for women to practice. And that's one of my concerns. How do we ensure a level playing field for women who are practicing? And I think there, the responsibility is not just of the judges themselves, but of members of the bar themselves. Senior members of the bar, for instance, must make sure that they make their chambers places which are accessible, which are welcoming of women. I think our chambers must factor in that women have very significantly different societal responsibilities than male lawyers have. We must factor in the fact that women have a very large role to play in terms of the work which they do for their own families, and therefore, in terms of childbearing, therefore, we must ensure that women are not put out of the profession by these challenges which womanhood brings to a member of the bar who's a woman. So I think there's a greater societal responsibility, and not just a responsibility which we place on those who are in the collegiums, but the whole structure of the bar has to undergo a change in making these spaces more welcoming of women, so as to ensure that more and more women enter the profession of the courts, lawyering within the courts, that they succeed in the process of litigation as litigation professionals, and then eventually are appointed to the high courts and then to the Supreme Court. But diversity is not a matter of only gender. And during my tenure as both a High Court judge, as the Chief Justice, and now as a judge of the Supreme Court, we've been trying our best to ensure that the Supreme Court resembles, should I say, the character of the nation by having women judges into the Supreme Court, by bringing judges from marginalized backgrounds, by bringing in judges to the Supreme Court from diverse religious groups. Now, judges who have been appointed to the Supreme Court to bring in a great sense of diversity are not brought in because they belong to a particular religion. That's not how the process works. They've been brought in because they are among the best in the country. But while bringing in the best from the country to the Supreme Court, we also have an eye on having this broader sense of diversity in terms of gender, caste, marginalization, religion, in bringing diverse segments of our society into the Supreme Court.
Let me seek your opinion now regarding the latest judgment on Article 370, the Constitution bench judge, the judgment which came very recently. You were part of that judgment. So there has been a lot of public criticism on that judgment, especially by Justice Nariman, your former colleague and your former senior also, his father Fali Nariman. They have spoken publicly criticizing the judgment on 370. So how do you respond to that criticism, especially the issue of statehood, which they have tried to address, that the Supreme Court did not venture into that? So can you elaborate on that?
Etisham, a judge who decides a case speaks through their judgments. Once a judgment is delivered, that judgment becomes public property of the nation. Until a judgment is delivered, the process is confined to the judges who are involved in the decision of that case. Once we arrive at a decision and the judgment is pronounced, it's public property, it's the property of the nation. We are a free society. We have a constitution which protects the right to the freedom of speech and expression. And therefore, people are entitled to exercise the right to freedom of speech and expression, to critique, to criticize, to appreciate. So far as we are concerned, we decide according to two parameters, the Constitution and the law. And I don't think it will be appropriate for me either to respond to criticism or to mount a defense of my judgment. What we have said in the judgment is reflected in our reasons which are contained in the signed judgment, and I must leave it at that.
As you said that judges speak through their judgment, but still I'll ask another question regarding another of your judgment regarding that same-sex marriage. It was very close to your heart also, the way I saw you dealing with this case. Do you find some kind of regret that it didn't happen the way you actually wanted it? Because you have been vociferously speaking about it since long, and it was due to a large number of LGBT community. How do you reflect to that when you look back?
The LGBTQ community has fought a long and hard battle in the realization of their rights. To a certain extent, there was a watershed in that evolution when the Supreme Court decided Navteej Johar. The recent judgment was a judgment where that community, the LGBTQ plus community, the queer community, sought a recognition of the right to marry. I'm not going to comment on the merits of the judgment, for the simple reason that I want to share something with you which is very personal, and which is that over the years of training which we acquire as judges, you put everything into a case when you are deciding it. Obviously, when you are hearing a case, when you are reasoning for yourself what should be the ideal outcome of that case, when you reserve a judgment, when you are lost into your own thoughts as an individual, you're reflecting very deeply. But one thing which our training teaches us is that once you deliver a judgment in a case, you kind of distance yourself from the outcome. Outcomes are never, in that sense, something which are personal to a judge. You decide a case based on your vision of the Constitution, on what you believe the vision of a just society for the future is, in constitutional terms, which is what I have done. I never have any regrets. Yes, I've been in a majority in many cases, I've been in a minority in any cases, but the important part about the life of a judge is never to associate yourself with the cause. Because it is only when you don't associate yourself with the cause after a judgment is delivered, that you can truly be dispassionate. Having decided a case, I leave it at that and leave it for the future of our society to judge what course the society should take.
Sir, I saw you in one of the hearings speaking on bench hunting, or some people objecting to certain cases, politically motivated, politically important cases, as they said, given to a particular judge. How do you respond to that? Is it happening, or what is behind all this, the kind of allegations which were made against the Chief Justice of India?
Well, I must tell you that there are very well defined structures and processes for the allocation of cases. First, the roster by virtue of which cases are assigned according to subject matter is printed in advance under the authority of the Chief Justice. So the roster is notified for everyone to see, and it's in the public realm. It's published on the website of the Supreme Court. Second, that's equally important, every judge of the Supreme Court is a judge of the Supreme Court. Every judge is entitled to decide any case which is assigned by the Chief Justice to them in terms of the roster. Third, and I've been a member of the bar as well, no lawyer can insist that I will have my case decided only by a particular judge, because that does not do justice either to the credibility of individual judges or to the purity of the administration of justice. Fourth, there are well-defined processes. Cases are assigned by the Chief Justice when a case comes up for assignment. For instance, if a judge recuses themselves. Normally, cases are assigned according to roster automatically by the computer. If a judge recuses, case is put up before the Chief Justice, and the Chief Justice will then reassign that case. The reassignment may be to a senior judge, it may be to a junior judge. Once the case is assigned to that judge, that case follows the judge. Unless, for instance, the judge falls sick and says, well, I don't want to take up
As
that
it
case.
happened in
I
this
don't want
case.
to take up that case because I'm not on duty for the next month, in which case it has to be reassigned. But I'm very, very clear in my mind that if the credibility of the institution of the Supreme Court is to be maintained, we have to ensure that the allocation of cases in the Supreme Court is not going to be a lawyer-driven allocation. It has to be an allocation which we do in terms of our processes and systems which are laid down in the Supreme Court. Having said that, I can only say that, well, you have to trust your decision makers.
So one final question, again regarding one of your important judgments, that is the Ayodhya judgment. You were part of that bench. So it is very, I mean, everyone is curious to know who authored the judgment, because it happened for the first time that the judgment did not carry any name who authored the judgment. So can you now reveal what exactly was behind that, and who actually authored that judgment? Many believe that it's you. Can you please elaborate to us, because the issue is now almost over and the temple is to be inaugurated this month only. So who actually authored the judgment, and why it was kept secret still?
Well, when the five-judge bench sat to deliberate on the judgment, as we all do before a judgment is pronounced, we all decided unanimously that this will be a judgment of the court. and therefore there was no authorship ascribed to an individual judge. The case had a long history of conflict, of diverse viewpoints, based on the history of the nation. And all of us who were part of the bench decided that this will be a judgment of the court. The court will speak through one voice. And the idea of doing so was to send a clear message that all of us stood together, not only in the ultimate outcome, but in the reasons which were indicated in the judgment. And that was why we decided that this will read as a judgment of the court. Since we decided that this will read as a judgment of the court, it will always remain a judgment of the court, and I'll close my answer with that.
It was a pleasure talking to you, Chief Justice of India, Justice D.Y. Chandrachud. Thank you so much for giving your precious time and talking to us at length. And thank you so much.
Thank you very much, Etisham. It's been truly a pleasure. Thank you very much.
Thank you, sir.